Hi everyone, this is Sean. Welcome back to my channel. Today I'm taking a walk after my mile run, and this is my cool off time. There's something I want to talk about, and that is private security officer involved shootings. And what should you say to your supervisor? That's something I want to cover. Guys, if I cough, sniff, or sneeze, please forgive me. I'm trying to fight this cold that I've been having since August. I just can't shake it off. If I pause for an unusual amount of time, I apologize as well. I have absolutely nothing to show you on camera. If you would just listen to the audio, I think you're going to gain a lot more from the audio than the visual. So if you're ever involved in a private security officer shooting, I have done numerous videos on what you should do and what you can expect. In today's video, I'm going to narrow that subject down to what should you say to your supervisor. Because if you are in California, in my state, you're required to notify your supervisor within 24 hours of the incident. Now, most would think immediately, but the state, California, allows us 24 hours to make that report. In turn, you and your employer have 7 days after the incident to report the incident to the Bureau of Security Investigative Services, also known as BSIS. They are the regulatory arm for private security professionals in California. In Florida, they have the Department of Agriculture. Other states, I think it's Texas, they have the Department of Public Safety that monitors, that administers private security oversight. So let's talk about this. Okay, so we're going to skip talking about the conversation that you would or would not have with law enforcement. This is just your supervisor. And it would be awkward in a way not to say anything, right? I mean, they're your supervisor and they have a right to know what is going on. Now, your ability to communicate with them is going to depend on whether or not you are a unionized employee or a non-union employee. If you are a union employee, your labor agreement will spell out the terms and conditions of that type of communication. If that type of communication or the incident could lead to disciplinary actions. And in most circumstances, an officer-involved shooting can lead to a disciplinary action if it was done out of policy or done outside of state or federal law. We know that already. My recommendation is always to contact an attorney. But if you're like most people, you probably don't have money to contact an attorney. And it is very unlikely that your employer is going to hire an attorney just so that you can have a conversation with them. But that's my number one recommendation. This is just my personal advice. This is just something that I would do if I was a private security officer involved in a shooting and I had to communicate with my supervisor. I would keep it simple. I would just say that my life was threatened. I thought I was going to die, and my firearm was discharged. There was no innocent people hit, and that's it. I will leave it as that. Can your employer, if you are non-unionized, can they terminate you for not providing more information? Absolutely yes. Even if you're a unionized employee, you could still be terminated if you're given an order to speak on what happened and you refuse to do so. But remember, what you say to your supervisor, it's not privileged communication. So if your supervisor gets subpoenaed to court and they are ordered to testify as to what the conversation was between you, they cannot claim any type of legal privilege. And basically, the layman's definition of legal privilege is if you're one of the parties to this privileged communication, you don't have to disclose what happened, what the conversation was about. It's kind of like an attorney. You consult with an attorney for legal advice. That attorney does not, or actually you can have your attorney not disclose the communication that you had with him or her. That's called a legal privilege. So is it a good idea to speak to your attorney? That's up to you. Just remember, they can terminate you. If you are not a unionized employee, you don't have a whole lot of rights, and you can be terminated for any reason. At least if you're unionized, there is a time and place for these types of interrogations. So that's just something to keep in mind. And also, this video is meant for those of you who are in private security, not security connected to any government contract, or not any type of security where you are working directly for a government body. Now remember, security who are connected to government contracts, you might have a little bit more rights than others, but it just depends on the labor agreement. If that makes sense. If it doesn't make sense, let me know and I'll break it down to you in the comment section below. So what do you think? What would your limits of discussion be to a supervisor if you are involved in a shooting, or even a manager or the owner of the security company? And I'm sure that if you own the security company or you manage the security company, you want to know what happened. But if you understand law, you understand criminal procedures, then I think that you would understand why your employee would not make a full statement. Just remember, that communication between both of you, it's not privilege, guys and gals. It's not privilege at all. And what's it going to hurt the company if you just give this employee time to consult with an attorney? Because in California, the state law just requires your employee to notify you as an employer within 24 hours. That's it. And you have 7 days to report it to the state if you're in California. Other states have different requirements, but it seems like there's a general consensus among all states that there's some type of reporting period. That's a lot of time. Do you need a statement right now at the minute, or can you just get a generic one and afford your employee the rights that they deserve? Because in the end, if this goes to civil litigation, okay, you don't know if the plaintiff is going to side or not sue your employee personally in exchange for some testimony, right? You don't know that. And you don't want to have a disgruntled employee who leaves your workforce. That's not a good thing. All right, guys, looking forward to the dialogue. Take care.